Hello, I'm Nadia McLeod from Emery Legal Kits, and we help you cut your legal costs with our online template kits. A restraint of trade clause prevents employees from certain activities after they have left the company. These activities could include setting up a competing company, passing on commercial secrets, or working in the same role for the competition. A restraint of trade clause must be specific and last for a reasonable time frame. Employees take important skills and knowledge with them when they leave a company. If the competition obtains this knowledge, it could damage your company. For this reason, many employment contracts include a restraint of trade clause that protects trade secrets, client relationships, and confidential information. There are 4 types of restraint clauses. Non-compete clauses ensure that employees cannot form competing businesses within a certain time frame or place. Non-recruitment clauses forbid employees from trying to convince other employees to join them in a competing business. Confidentiality clauses prevent employees from using or disclosing information that could harm a business. And non-solicitation clauses prevent enticing clients away from a company. Many of these clauses overlap, and this redundancy helps protect your business. A restraint of trade clause must be considered reasonable and necessary. It cannot impede the ability of the person to gain further employment. While the definition of reasonable and necessary can differ between industries, some general elements are found in all contracts. An effective restraint of trade clause limits only specific activities. It cannot, for an example, prevent an employee from taking any role in another company, nor can it prohibit taking roles in companies that are not direct competitors. A restraint of trade clause must have a reasonable time frame, generally between 3 months and 4 years. Most importantly, the clause must reflect the roles and duties outlined within the employment contract. Some restraint of trade clauses can be far more protective than others. Confidentiality clauses, for example, often have much longer timeframes and are more general in protecting trade secrets. For many companies, a separate confidentiality and non-compete agreement is an essential part of an employment contract. Emery provides agreement templates designed for Australian businesses. Designed by business lawyers, these documents can be used time and again and tailored for your industry. Using these templates to create your non-compete agreement can help you develop a fair and reasonable relationship with your employees. For more information about restraint of trade clauses, check out the links below. And if you want to solve simple legal problems, cut costs, and take control of everyday legal issues, please click the subscribe button.